allow me to do anything.
I'm the judge, Attorney Bijani. I'm the one who makes that.
What
I meant was object to anything.
Your Honor.
It doesn't just go to this case, but many cases, it's how people are manipulated. The whole federal government
Can we mute her for a minute?
Assist people.
How much is owed on the judgment? How much is owed on the judgment?
Over 50,000. I mean,
well, it depends on how you look at it. They keep rejecting the 25,000 from
Attorney Bijani. Excuse me, Attorney Bijani. Were you offered 25,000 on 50,000?
No, she's a liar.
On this matter, we need to address the matter that occurred yesterday.
Yes, Your Honor.
Okay. On May 8th, 2023, the court held a hearing on a motion to stay eviction, which was filed by the defendants. That hearing was held in case number 19361180, ACP Nash LLC versus Rolanda Campbell. During the hearing, you displayed increasingly disrespectful and deplorable conduct. That conduct consisted of you using hand gestures as well as using profane language on the record. Attorney Bijani, I don't know what was going on with you yesterday. Everybody is entitled to a bad day. I don't hold grudges, but I do need to tell you on the record that if you ever behave like you behaved in my courtroom yesterday, I will find you in contempt of court and fine you. And if I need to, issue a warrant for your arrest. Like I said, everybody has a bad day. Attorney Bijani, I do notice that, since we've been over Zoom, there has been a, I don't know, I guess it's not, the attorneys as well as the litigants are not, I guess, being as professional as they would if they were in person proceedings. However, Attorney Bijani, I do need to remind you of the decorum and the respect that is owed to this court. And as I told you yesterday, you did disrespect this court. You disrespected me. You disrespected yourself as a member of the State Bar of Michigan. You did take an oath as an attorney of the State Bar of Michigan. You took an oath to first, maintain the respect due to the courts of justice and judicial officers. You also took an oath to conduct yourself personally and professionally in conformity with the high standards of court conduct imposed upon the members of the bar as conditions for the privilege to practice law in the state. And Attorney Bijani, I'll tell you, in my almost 20 years of practicing, I have been a litigator for 95% of that time, and I am all about zealous advocacy on behalf of a client. I'm all for it. I don't mind when an attorney zealously advocates for a client. I have seen many attorneys zealously advocate for their clients and do so very eloquently and passionately. But in my near 20 years of litigation experience and as clerking as a judge and interning for a federal judge, I have never witnessed an attorney curse and use the language that you used in court yesterday, nor have I witnessed an attorney make potentially offensive and maybe threatening hand gestures during a court hearing. And I don't appreciate it. Again, I don't hold grudges, but as I stated, if you do it again, Attorney Bijani, I will find you in contempt. And I just wanted to put that on the record, okay?
I understand, Judge. May I respond just briefly?
Sure. Briefly.
I disagree that I made any hand gestures that were demonstrative, and I also disagree that I use any profane language. However, I do agree that I let my emotions get the best of me under the circumstances, and I strongly apologize to the court and to opposing counsel as well as Your Honor.
Okay, well, I accept your apology, Attorney Bajani, but you can disagree all you want to. The YouTube is up. You can go look at the YouTube. If you don't remember using profanity, I will direct you to my YouTube for yesterday. You used profanity. I'm not lying. I'm not crazy, and I'm not imagining things. And you did make some hand gestures. I'll direct you to the YouTube. Like I said, I don't know what's going on. I don't know what was going on. Everybody's entitled to a bad day, but you're not going to pretend like it didn't happen. It did happen, and I'm going to keep the YouTube up for you and anyone else to see if necessary, okay? I do accept your apology, and we can move on. I don't hold grudges, but don't do that in my courtroom ever again.
Understood. I won't, Judge.
Okay. Attorney Bajani, I just want to tell you there are reports that you are vaping. I don't know if that's true or not, but I hope not, because there's no smoking in court. And we already had some issues with yesterday. So if you are doing that, please don't do it. Thank you.
Thank you, Judge. With regards to that video, Judge, can we go off the record for a moment?
We're not on the record. I don't know how to.
We're on YouTube.
Well, no, I'm not. What do you want to discuss?
Off of YouTube.
Okay, I'll go off of YouTube after we finish the 2 cases. Is there something that needs to be addressed before we finish the 2 cases?
No, Judge.
Okay. Now calling case number 19361180, ACP Nash LLC versus Rolando Campbell of 16261 Wisconsin in the city of Detroit. This matter is scheduled for a writ hearing. May I have appearances, please, beginning with the plaintiff.
Judge Eli Bajani, P74626, on behalf of the plaintiff.
Good afternoon, Your Honor. May it please the court, Vanessa Fluker, P64870, on behalf of Mr. Campbell.
I see that Mr. Campbell is present, sir. Please state your name.
Rolando Campbell. Good afternoon, Your Honor.
Good afternoon to you, Mr. Campbell. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can lower your hand. Okay, to the attorneys. Attorney Bajani, you have the floor.
It was my motion and he didn't follow.
You're right. It's your motion, Attorney
I want to
Fluker.
discuss is the housekeeping on that. And I'd also like to get screen share rights as all possible. That's very
Which
important.
motion is this?
It's a motion to stay eviction. So that is defendant's motion, right?
That's correct.
I thought today was our writ hearing.
Well, there's an intervening motion. That's why I need screen share, because I want him to say he did not receive service, because I have an email confirming his service. Is it possible that I can screen share?
Well, Judge, don't you think it's proper for me to state my case before the defense counsel?
Oh my goodness
He doesn't
gracious.
have a motion pending.
I have a writ of eviction motion.
Okay, let me see. There was a writ of eviction that was submitted to the court on April 11th, 2023. I did not. Can I finish speaking?
Yes, because that's erroneous right there, because of a writ issued in November. And we didn't know about it until January. I filed this motion to stay everything into this hearing. Now, if it was a writ issued on April 23rd, all the more reason we need to screen share, because there's something.
I said submitted to the court, meaning filed, a request for a writ filed.
Well, why would that be even submitted and filed if the other writ in motion had not been heard yet? And see, that's a problem with all these different registered actions and everything else, which I'm gonna try to do the abbreviated version here, but this is it's a lot. He can go first, it doesn't matter, but I do need screen share privileges, because this is a little bit out of control with respect to how all this has occurred. And it's like we can just quash due process rights, and that's a little problematic.
Judge, I have no idea what Ms. Fluker is even talking about right now.
Well, we'll know soon enough, and I'm sure you will.
Well, I mean, did you get the motion, Attorney Bajani? There was an emergency ex parte motion to stay execution of judgment and writ of eviction that was filed on January 31st, 2023.
Yes, I have received that.
Okay, well, I guess that's probably what she's talking about, right? I would assume, but maybe I shouldn't do that. Attorney Fluker, what are you trying to share?
I'm trying to share his email response to the motion.
No, I object to that.
Threatening. I know you wouldn't object to it because he literally threatened me that his client's worth $100 million, that the judges of the 36th District Court are basically incompetent as crap because they won't rule in his favor with no case law.
Yeah,
And
I
I
don't
think
know.
the court needs to see that.
Judge, that's
And it's not
information.
hearsay because it's directly to me. Now, why he would do that, this just goes to show this long history that we have of I fight for justice, and he's not with that program. And I would like to screen share that.
That's information discussed between counsel and it's inadmissible under the court of law.
That is wrong because it's not discussing.
So
any
I'll
type
say
of
this,
settlement
Attorney Bajani.
negotiation.
I have had attorneys attach my emails to motions as exhibits.
And
So
it is not
where
MRE
what under
408.
well, we'll start with you, Attorney Bajani. What rule of law or what court rule or what are you relying on to say that it's not admissible?
This communication between myself and opposing counsel. It's protected under the Michigan Rules of Evidence 4.08. It's inadmissible.
Hold on. I'm going to Michigan rule of, there's a Michigan rule of, let me see, Michigan Rules of Evidence.
That goes to settlement and compromise.
Which Michigan Rule of Evidence are you referring to, Attorney Bajani?
408.
408. Compromise and offers to compromise. Evidence of 1, furnishing or offering or promising to furnish, or 2, accepting or offering or promising to accept a valuable consideration in compromising or attempting to compromise a claim which was disputed as to either validity or amount is not admissible to prove liability for or invalidity of the claim or its amount. Okay, so that's why you can't use it to prove liability or invalidity of the claim. Evidence of conduct or statements made in compromise negotiations is likewise not admissible. This rule does not require the exclusion of any evidence otherwise discoverable merely because it is presented in the course of compromise negotiations. This rule also does not require exclusion when the evidence is offered for another purpose, such as proving bias or prejudice of a witness, negativing a contention of undue delay, or proving an effort to obstruct a criminal investigation or prosecution. So, what are you offering these communications for, Attorney Fluker?
I'm offering them to definitely show bias. There's nothing in it that shows compromise. There's everything in it that shows an element of intimidation, in my opinion, and the opinion of others who have reviewed it.
Judge, this was a statement that I gave to Ms. Fluker, reminding her of how I'd rather not say.
I think the court needs to review it and you can assess it for yourself.
Well, I'd rather
like
not
to-
say it on the record because it's not admissible. I'm not gonna put myself out there and expose myself to anything that I don't have to. Judge, everything that I stated in the supposed alleged email has no bearing on this case. Absolutely nothing. Unless Ms. Fluker can prove otherwise.
Well, obviously I feel I can't, otherwise I wouldn't be submitting.
I'm not gonna allow you to screen share your document.
You can't not allow me to do anything.
I'm the
You are
judge,
not the
Attorney
judge.
Bajani. I'm the one who
That's
makes
one of
that.
the
What
problems
I
that
meant
we
was
have.
object to anything.
Your Honor, I'm sorry. I
Oh,
can't.
we're not about to start that. We're not about to start hollering at me. I hope you're not hollering at me, Attorney Bajani, because I don't respond well to
I
that
wasn't.
at all.
But Judge Fluker was also hollering, and I never heard you say anything to her.
I'm not yelling. You're the one that seems to be upset. And you're the
Attorney
one that
Fluker,
drafted
I'm not
it.
upset. I'm the one that had the last laugh, if anything. So you seem very upset.
Well, we'll see.
Y'all are being petty, okay? Or Attorney Bajani, that last comment was not, it wasn't even necessary. I'll say this, Attorney Fluke, I might be loud talking, but I'm a loud person. So, once I get amped, I start talking loud. I'm not trying to holler though. I'm just trying to make sure I'm heard. Attorney Fluker, her audio is terrible. So I didn't hear her hollering. I didn't hear any hollering on Attorney Fluker's behalf because It sounds muffled like 95% of the time. But what I did just witness, Attorney Bejani, was you hollering. Okay, don't do that to me again, please. Don't do that in my courtroom again.
Sorry,
Thank
Judge,
you.
I won't.
Your Honor, I would like to have screen share capabilities.
I object, Your Honor.
Okay, you object. You based it on Rule 408. But what I read is, I think Attorney Fluker said you were offering it to show what? Bias?
Yes, bias and intimidation. In fact, I think it would be a firm candidate for a violation of MCR 1.109E.
1.109E.
Okay, y'all
For
making me work
purposes
hard
of
for my money
intimidation,
today. Let's see.
harassment of the litigants, the parties.
Judge, how is that relevant to this case, though?
MCR MCR what?
1.109E. It used to be MCR 2.114 and they changed it.
Okay, well, let me get my brand new rule book. Coming in handy today. MCR 1.109E. MCR 1.109 talks about court records and signatures. 10109E specifically talks about signatures. What exactly are you referencing, Attorney
And when you look
Fluker?
at this, you read down, when you put your signature or something with the intent to harass, intimidate, cause undue delay, et cetera, that's what I'm talking about. And this email will speak for itself.
Right. And it had
Where is it at? Give me an exact pinpoint site to the court rule.
I believe it's E5 and 6. Actually 4, 5, and 6. It talks about asphyxiating the signature. Then it talks about for the improper purpose of undue delay, harassment, intimidation, et cetera. Then the next section talks about the court's authority to assess sanctions and things of that nature.
Yeah, and we claim
So
those.
that talks about signatures on pleadings, right?
It says pleadings and documents, I believe.
Okay. Before I decide on whether to allow Attorney Fluker to share or not share this document, what is the crux of the reason we are here today?
Thank you, Judge.
Well,
I'd like to start
thank
with
you.
that. I'd like to start with that, Judge.
Well, see, that's why it's important that we talk about E. He loves to talk, but he doesn't want to respond in writing. He doesn't want to rely on court rules. He doesn't want to rely on case law, which is what brings us to today, because they filed a dang on writ order without giving anyone notice. In fact, I was in the hospital and the matter was up on appeal. And if you look at the register of actions, you will note it says eviction order entered with no clerk by it. My client receives a envelope with nothing in it, which when he came down to 36th District Court, because I was still sick during that time period, 36th District Court advised him they did not send that letter out, which is why I ended up filing this emergency motion and all this other stuff. I mean, it's just, and to date, despite it being delivered numerous times, the appeal documents are still not in this register of actions. And if we
What are not in the register of actions, Attorney Fluker?
the appeal, the claim of appeal. If you go back through the history of this case, we have some other ROA issues, which is why we had to have an amended judgment, because the judgment was never sent out to us. The file was mysteriously lost for this period of time. And suddenly out the blue is this, mysterious writ of eviction. This is like our second.
Attorney Fluker, when was the claim of appeal filed?
Claim of appeal was filed in June of 2022. And the transcripts were not even finalized until September. It was one of those type of scenarios. The case started out with Judge Pitty Millender, and you know how it is. You get like 2 or 3 hours a day. By the time it got to Judge Garrett, I don't know. We might have been on part 10, 15, whatever. But it went through a full-fledged trial with several court reporters, and all those transcripts were ordered. And the more interesting issue was, if you just want to be technical about it and look at the court rules, there was escrow paid during that time period. And when we advised that we were taking an appeal we ask that the escrow be held in the escrow account and escrow continued. Mr. Virginia, his client, did not want that. They wanted that $12,100 immediately released, which the judge released. If you look at MCR 2.202K, that was a payment on that judgment, which at that point brought it down to $56,000. Then my client had gotten approved for my half, which has been sitting there for almost a year, $25,000, which Mr. Virgiani's client will not take because his house just happens to be in an area that is becoming very popular as far as gentrification and price increases. So that $25,000 is sitting there. So in essence, we're arguing over about $18,900 because this home was actually a land bank home and was never brought up to code. My client spent an exorbitant amount of money to get it up to code. That's the extremely, extremely short story. But for procedural purposes of this hearing, once again, we get this mysterious writ envelope. We didn't even get a copy of the writ. My client literally had to come down and talk to the chief of the clerks, Mr. Jackson, to get a copy of this writ. And now the stuff was properly put in the record. He's like, Ms. Fluker, I see the transcript, but I don't see your claim of appeal.
Judge,
We take it down again. It's attached to my motion. And Mr. Virginia knew the claim of appeal was in there because he put it in the appearance. Yet and still we're running around getting all these, filing all these backdoor writ things without notice. And it's just ridiculous. And that is why my email is so very important. Because the email point blank says, hey, you're costing my client money. My client's worth $100 million and we're coming after you. And I'll let you read the part for yourself about what it says about the 36th District Court and its judges.
Judge, the only thing that this court has to determine right now is,
And I haven't even gotten into the meat of the legalities and the law of the motion.
I still have no idea what Ms. Fluker's talking about. Judge, this is a land contract forfeiture, and it started from 2019. We aggressively litigated this case for over 4 years nonstop. Hence the 3-foot long file that you're looking before in front of you. There's a lot of documents in it. The defendants called us witnesses. We had a full-blown trial. I had to fly my clients in from New York to testify in person. All those matters are resolved. And this case goes back to your predecessor's predecessor. This started with Judge,
Melander,
and then it transferred to Judge Garrett, and then now it's before. There were several attorneys that were assigned to this case, but me and Ms. Fluker and I have pretty much took the reins for the most important part of this case. This case has been appealed 3 times to the circuit court. All 3 times they were kicked down and denied. Some with prejudice, some without. The Judge Melander denied all of Ms. Fluker's claims regarding affirmative defenses. Somehow it got passed through Judge Garrett. Judge Garrett ruled into a favorable outcome and judgment for Ms. Fluker, yet Ms. Fluker is still determined to prolong this case and attempt to file an appeal 1 year after the judgment was entered, claiming that she never received the judgment in the mail. And then now she's claiming that she never received the writ in the mail. I can easily forward it to her within seconds. I don't think that's even an issue. But the bottom line is, Judge, today's our writ of eviction hearing after a land contract. So what this court has to determine is whether the defendant paid the amount stated in the judgment by the specified date laid in the judgment. Otherwise, if not, then this writ must be issued in accordance of law.
Your Honor, I was trying to keep this as simple as possible, but I see that's not going to be possible. There was a circuit court matter associated with this case, which I did not represent the client on. It was totally separate for, I guess that's some of the appellate stuff that he's talking about, which he wasn't a part of either. But as far as this case is concerned, with regards to the initial judgment after the trial, when they finally found the file, The court saw that based on the matter of fact, you can look at my brief as a part of my exhibits. I think it's exhibit 3. The initial judgment was mailed out allegedly after the expiration date of the appeal time, which we
Yeah,
never
but
had.
we fixed that. Did we not?
And that
Attorney
Yeah,
Bajani,
I
please don't
think he was
interrupt.
Judge,
Please don't
So-
interrupt.
So that's disingenuous when he makes that statement. That was the first error. And they were very upset about that because it had to be amended. We filed our appeal after that was taken care of, which obviously delayed things quite a few months. After that, they come in after the appeal was filed the second time and got a writ of eviction without a hearing, I might add, after taking $12,100 towards the judgment, and no one had any knowledge of it. And no one has explained, and my client's here to discuss that. I did not personally come down to the court. At that time, I wasn't even mobile at all. He went down to the court with the envelope from 36th District Court and spoke with the Chief Judge's office and the clerk's office, who advised him that that envelope and that letter did not come from the 36th District Court. But yet and still there's a writ entered to evict him. And they're saying, Ms. Fluker, we still can't find your actual appeal documents. But everyone knows it's an appeal. It's just been a mess. There should have been proper notification because all this would have been nipped in the bud early on. And when he filed the alleged writ documents, I think I was headed for surgery number 3 or whatever. When that stuff was filed, which everyone knew about. That was a whole nother side pet peeve for me, how you can advise the court of your medical situation, but if you look a certain way as ignore, but then someone else come in and say, I need an extra 30, 45 days for vacation conflict, it's not a problem. I'm not going to go off on that tangent today. But the bottom line is that none of this stuff was properly entered. It was a pending appeal. Now, because the pending writ is here, I can't even go back up to the appellate court to Judge Murphy until I get something saying that this writ, not the order, is set aside. And I don't even understand how you would be doing this without a hearing anyway. When they got, MCR 2.2, 4.202K is clear. If any part of the judgment is paid, you got to have a hearing. We argued ad nauseum over that $12,100 because I said it should stay in the escrow pending the appeal. And they didn't know our client deserved to get it now. And that's in the register of actions that it was released. So why wasn't there a hearing? That in itself is enough to reverse it, aside from the fact that we did not make any response whatsoever. And contrary to the representations in prior hearings, there is nothing that says you can make oral doggone responses on the record to any motion except for 4.201, and that's an answer to a summary proceedings complaint only, not motion. And under MCR 4.202, it specifically articulates that court rule, because you're dealing with a land contract, is governed by the rule of general pleadings. And if you know anything about civil litigation, you know that MCR 2.119 requires you to respond in writing supported by competent authority. That means you need to be cited to a statute, a court rule, a case, or something in writing, not coming to court posturing about how you think you deserve a certain outcome.
No, I'm sorry, Ms. Fluker.
And I once again would
would
like to have a screen share, because something that's just as significant, and it doesn't just go to this case, but many cases, is how people are manipulating the whole federal government.
Can we mute her for a minute?
Assist people.
I'm gonna mute you. I'm muting you because she's talking, and you
We have the whole
interrupted.
my half thing. My half is the component for people who were homeowners or potential homeowners to assist them with payments. If you look at my exhibit 10 to the motion, you will see that a year ago in March 2002, the $25,000 was sitting there to be tendered to his client, but they refused to accept the money. Mr. Campbell has emails from a few days ago. Look, we're still trying to hold this money. We keep emailing these people with encrypted emails so they can sign and get the money, which is another $25,000, which that was the $12,100 has already been paid. We're actually arguing over $18,900 which my client has extensive expenses with respect to redoing plumbing, electrical, and things of that nature, which is our reason for the appeal. So him coming in acting like there's all of this, drama is not, other than the mere fact they decided, oh boy, this house is in an area that's now kind of on the come up, as the young kids would say, and we want to take the property and not the money. They're trying to circumvent this person's rights as a matter of law by doing it. Specifically under MCR 2.612C, it talks about if there's been any type of excusable neglect, mistakes, error, things of that nature. You can look at the register of actions. Where was
what is that law you just cited, Attorney Fluker?
That's the court rule, MCR 2.612C1. That's the motion to set aside judgments and orders. And specifically, it states, it provides that you can set aside judgments and orders if A, mistake, inadvertent, surprise, or excusable neglect, which is one of the provisions that we're relying on. B, newly discovered evidence, which is by due diligence, could not have been discovered in time to move for a new trial under MCR 2.611B. Fraud, intrinsic or extrinsic misrepresentation or other misconduct of an adverse party. D, the judgment is void. E, the judgment has been satisfied, released or discharged the prior judgment on which has been reversed or otherwise vacated or is no longer equitable in any way or should have a prospective application. And F, any other reason justifying relief from the operation of the judgment. And we rely on sections A and sections F. And specifically articulated in the brief, and I won't go through the whole brief, I'm sure you have a copy. The one thing that's very much on point is the Michigan Court of Appeals decision in Fisher v. Belcher, 269 Mishap 247 and 262. That's a 2005 published Court of Appeals case where it says, a court may set aside an order on a number of grounds, including mistake, inadvertent, surprise, or excusable neglect. MCR 2.612C1A, a party is relieved from final judgment order proceeding on the basis of mistake, which mistake may be made by the trial court, citing from Altman v. Nelson 197, Mishap 467 at 477, 495 Northwest 2nd, 826, 1992. Bottom line is, you can look at the Register of Acts. There was never anything mailed out by this court on a writ order period. There was never a hearing set. In fact, there's not even a clerk's name next to when that order was entered, which is suspect in itself because it's like 15, 20 pages of stuff on Register of Actions. And if you go through and look at all those pages, any other order that was entered, anything like that, it states the judge, it states the court clerk, it states the little number, whatever the case may be. Only time you don't see that is when the file mysteriously disappeared and we didn't get that judgment and on this writ order. So that in and of itself is a base. Then, of course, by me going through at that point, surgery number 3, because of my illness, we have the excusable neglect. If I had known about this, I'd have been on this like 2 days after it happened, not 30 days when my client got an empty letter, which of course is supported up by the documentation in there along with my affidavit and the applicable case law, which is the
Attorney Fluker, is the empty letter attached as an exhibit to your motion?
1.
Exhibit 1?
Yes. And my client is here, and my client was here to testify because he brought it to the court and the court advised him that they did not send this out.
Then who did?
I don't know.
So what are you suggesting, Attorney Fluker? Because I'm hearing, mysteriously didn't show up in the Register of Actions,
but this is stuff you can look at it and see. And
so
I've had an opportunity.
What are you suggesting actually took place?
I'm suggesting that I don't know. All I know is that pursuant to the court rules, if it was done appropriately, not only would it have been entered and you could identify a clerk, it would have been set for a hearing. That's the court rule. MCR 2.02.
Okay, they get a letter run on.
No, I mean, it's right in the Register Act that talks about when the $12,100 was dispersed. In fact, when you came on board, there was still a motion pending in front of Judge Gear as to whether she was going to set a specific amount of the escrow, because she was trying to coax them into taking the might have $25,000 and sit in the escrow till the appeal was over, or continue the monthly escrow amount.
I have no
That
idea.
motion was never decided. If you look at the register of actions, you see that motion is still pending and hadn't been decided.
I saw
yet-
it.
Okay, I'm gonna stop you, Attorney Fluker.
Mhm.
Take me through the backwards. Has this court signed off on an eviction writ?
Yes.
Yes, supposedly yes.
And which one and what date? Because I do see several eviction writs
Well,
in the
the
register
one
of
I'm
action.
talking about, I don't even understand what's going on. The April 23rd, which is just interesting in and of
That's good.
itself. 'Cause
Mark,
I've never.
can you mute Ms. Fluker so I can at least say something without her barking over me?
Attorney Bijani, you're gonna get excuse me, hello, when I talk, I would like to be able for my court reporter to take me down. You're gonna have an opportunity to respond, Attorney Bijani, but come on now, stop asking me, can I mute her? That's rude. I'm not going to mute her unless she's talking and interrupting while you're talking, like I muted you when you kept interrupting her.
That's what's happening right now.
Your Honor, I think she
I
asked
see.
me
So
to-
let me just state that there is an order of eviction. I'm going backwards from the register of actions, okay? On April 24th, we scheduled a writ hearing for today. All right. For that, I see an order of eviction was filed on April 17th. Okay, so that is what is before the court today. I also see on January 13th, which is before, it was like probably the Friday or Thursday before I took over this docket, that there was an order of eviction granted, entered, and mailed. That was January 13th, 2023.
And that's
Now,
what we're here on. Because that's why I filed my motion in response to. That is what if you look at my response, which is why it was filed on January 31st.
I see that. Okay, thank you for clarifying.
Your Honor.
Now, why he tried to backdoor in another one, knowing that we were waiting on a hearing
Oh my
on this
God,
date, I don't know.
I can't do this anymore, Judge.
So what do you want to do, Attorney Bijani? And you're not going to wait for your turn to speak? I don't know what you're saying. Okay, Attorney Fluker.
And now you muzzle me instead. You let Ms. Fluker bark.
I didn't muzzle anybody. My hands are right here. My hands are in the air. I didn't muzzle anyone.
Go ahead.
And I don't really like, and I don't like that reference. Okay, I don't like you using muzzle because I didn't mute you, but I do have court staff that will ensure that there is order kept in this court. Okay, that's what they're here for. Attorney Bijani, what would you like to say in response?
Do I have the floor without Ms. Fluker interrupting me?
I just asked you what you wasting time, Attorney Bijani.
I
We
just
have
asked a simple
until
question.
4:30.
She just went
Before
half an
you
hour.
asked the question,
Okay.
I said,
That's
Attorney
only-
Bijani, what would you like to say in response?
The only thing that matters is this case was filed as an appeal to the Third Circuit, which has mandatory jurisdiction over this case. Whatever they rule comes back, we have to follow this case. And this happened 3 times. The most recent time was by Ms. Fluker, October 13th, 2022. It was dismissed, sent back down. At that time, we should have had an immediate writ of eviction. Yet we had to wait 7 months.
When was it filed and dismissed, Attorney Bijani? What are those dates?
Well, it was entered on October 13th, 2022.
By the circuit court?
Yes, by Judge Murphy. The case number is 22006942AV. And to remind you, this is the 3rd time that it went up to the circuit court, always denied and sent back because really all the arguments that were made were just frivolous. If you read them, every single argument was frivolous and had absolutely no bearing. I can't believe this case took 4 years. So at that point, that allowed us to continue this case, Judge. once they rejected Ms. Fluker's arguments that really had no bearing, it got kicked back down to this court. We filed for a writ of eviction, and we should have been granted it within 10 days upon receipt. Yet here we are 7 months later, when my client has suffered tremendously, where defendant's client has paid $100 on an $80,000 land contract. $100. That's ridiculous. $100 on a $70,000 contract. And here Ms. Fluker keeps going off about us being frivolous.
80,000 or 70,000? You said 80,000.
It went from 80,000 to 70,000 to 50,000. It doesn't matter. At that point, when a judgment was being entered, we're like, you know what? We don't care. We'll concede that we'll shave off $20,000 because we knew that the defendant wasn't going to pay a dime. And that's exactly what happened over 16 months ago and ever since then. And nothing has been paid since then. Today's the date and time scheduled for a writ hearing. There's nothing else that this court can do besides entering a writ of eviction. My client has suffered enough. It has spent thousands of dollars litigating this matter and lost thousands of dollars. Meanwhile, the defendant only paid $100 throughout the whole entire land contract. We litigated this case aggressively for 4 years, Judge. We don't have to relitigate it. So that's why I'm narrowing down the issue. You have to start from the judgment from the Third Circuit Court, which was entered on October 13th, 2022. And this brings us back to the judgment that was entered. You have to determine how much money did the defendant pay towards the land contract judgment since that date. The answer is zero. Therefore, this court has no other, you have no other decision to make. And quite frankly, Judge, you're obligated to enter a writ of eviction in favor of our client.
Your Honor, if I may, on my reply, that's why I want to screen share, so I could pop up the scheduling order from the circuit court. Because he's saying an order was entered remanding this case. The scheduling order went in, and my brief was due October 14th. I mean, in fact, I'm gonna read you the scheduling order. If you want to screen share, I can share this with you. You know, because this is just kind of surreal. But let's just read the scheduling order.
Attorney Fluker, I've just made you co-host. Go ahead. I want to see the scheduling order.
Hold on, Judge. Wait, hold on, Judge. How is that relevant? I object to anything that she shows.
It's very relevant.
Judge, we have an order from the.
He just said that it went back down to this court on the 13th. Excuse me, my brief was due on the 4th. I was in surgery that day. His brief was due on October 14th. Oral argument was to be heard on October 20th. As we all know, I was ill during that time period. So no, there was not any remand back down to 36th District Court on October 13th. In fact,
we have an order.
Excuse me. In fact, there was some confusion with respect to the second floor clerk's office because they did not see any remand down, and the circuit court, I can't even file anything up there because now we have the pending writ. And I think it's very disingenuous what he's saying. And if the court wants me to pop up that email, it'll put it all in line, because the bottom line is in the email is a flat out intimidation attempt. You know, if you keep pursuing this, my client's worth $100 million, and we're coming after you. You need to hide all your vehicles, et cetera, and some disparaging things about the 36th District Court judges. And
Judge,
I think it's just ridiculous.
Judge, we have a signed circuit court. We have a signed circuit court order by Judge John Murphy stating that her appeal was dismissed. So I don't know why we're still discussing this.
Well, let me ask this, Attorney Bejani. Did you submit it to the court?
Yes, I did. That was the first thing I submitted with my writ of eviction application. And I sent it to Ms. Fluker and to the defendant. Of course, they're going to say that it came with an empty envelope. It wasn't me who sent it. It was the court. And I don't see how the court can make that mistake. Yeah, so that just shows you, Judge, this is all frivolous.
One thing
is completely frivolous, clear. Judge. Your Honor, you need to enter our writ.
While he's sending
I
out
don't
all-
need to do anything, Attorney Bajani. You're not going to pressure me into making a decision. I'm going to make an informed decision, okay?
I'm not.
And let me just put that out there.
Your
I
Honor.
didn't mean that, Judge. I'm just letting you know that. Hold on, Ms. Fluker, do you mind? You
Go
had
ahead.
an hour and a
I
half to
just-
talk.
Well, you know, we both get an opportunity to talk.
We're recessing on this, passing on this matter. All right, back on the record. We have 5 more minutes. We're back on the
My
record.
whole point is that we have an order from the Third Circuit Court Judge John A. Murphy. He entered an order October 13th, 2022, dismissing Ms. Fluker's appeal, remanding it down to the 36th District Court. This court is obliged to follow that ruling. Her appeal was dismissed. That's a fact. Doing otherwise, we're not going to talk about doing otherwise. This court just has to follow that. In accordance with that order, we submitted an application for writ of eviction. And even though it took over a year to get processed, we lost considerable amount of time and money for my client. We're asking that Your Honor, enter our writ of eviction and immediately, forthwith, and mail it out to my client so we can enforce it.
Your Honor, I'm just going to say this. You know, I may not be as experienced as some, but I have been practicing about 20 years now. And as far as I know, when you're served with a motion, you're supposed to respond to that motion. And typically there's certain time frames for it that are regulated by MCR 2.119 if you're under the general pleading standards. If it's specifically summary proceedings, that'll be 4.201. This motion was filed in January. As I've indicated, and he has acknowledged on the record, he did receive this motion. He's had every opportunity to respond to this motion, to attach anything that he wanted to attach to this motion, but he didn't do that. He has elected to come in here without a single document, try to explain to you how this case has been going on for 4 years, or whatever the case may be, knowing, as he also admitted on the record, he and I came on at the end of this case in 36th District. Neither one of us were a part of the circuit court matter whatsoever, but he's trying to do that to try to embellish some time frame or something that's going to influence the court in their decision making, when the decision making must be based on the law. So let's look at the law. Number one, my motion was brought under MCR 2.612C1A and F. I supported my documentation with competent evidence and exhibit. He did not respond. Technically, as a matter of law, that's it. My motion is granted and the writ is set aside from his lack of non-response. The mere fact that you're even entertaining oral argument from him today is a very benevolent, discretionary gesture, not one that is required as a matter of law for a motion. And we are all aware of that if we're aware of the civil court rules. You don't get to just prance up in the court with no response and start arguing all kind of stuff, getting all adamant, and, intense and everything else. You didn't even file a response.
Yeah, but you can't.
And you had to know about it because you turn right around, instead of filing a proper response to the motion, try to file another writ of eviction, which is 27 arguments right there. Because
let me ask this.
Why would you be filing another?
Excuse me. Attorney Bejani, when you submitted the original writ that was signed off on in, I think, January, did you serve Attorney Fluker with a copy of the writ? Request for the writ?
Absolutely, Judge. Would I not serve anybody else? I made sure I left an envelope to her office and the defendant with the order dismissing the appeal to both her and her client, and I even left an extra copy in the court.
Okay. All right. If I may, Your Honor, I just have to respond to that because that explains like 9,000 things right there. He didn't say the court mailed down anything. He said he left a copy of the envelope at my office. I never got a copy of the envelope at my office.
Let me ask you, Attorney Bejani. Excuse me, Attorney Bejani, you said you left an envelope. Where did you leave the envelope?
Judge, the procedure for the 36th District Court, when filing for a writ of eviction, I leave an envelope addressed to my office to the defendant. And when there's an attorney that's represented, I leave an extra envelope for her. I even write a post-it on there stating that make sure you send a copy of the writ of eviction once signed to opposing counsel. And I attach the order dismissing Ms. Fluker's appeal, which completely eliminates her motion that she filed thereafter. I don't even know what she's talking.
Okay, I'm sorry. I have to cut this short. We're gonna have to adjourn this hearing to another date. Madam Clerk, can I get an adjourn date?
The next available date, Judge, is June 1st, unless you want.
Judge, honestly, I don't know how much longer I can deal with this. This case has been pending for 4 years, Judge. 4 years, and we keep getting the same results. Ms. Fluker comes on, she just keeps making off all of these frivolous arguments to confuse.
How much is owed on the judgment? How much is owed on the judgment?
Over 50,000. I mean,
Well, it depends on how you look at it. They keep rejecting the 25,000 from
We have
my
a
Attorney
account.
Bijani, excuse me, Attorney Bijani, were you offered 25,000
No.
on 50,000?
no, she's a liar.
If all you have to do is look at my exhibit number 10, and that will say it all. See, I attach
Exhibit
exhibits
10.
to my motion. I exact evidence. And I'm going to take homage with I'm a liar. And I definitely, matter of fact, when our next court date is, I'll just attach a supplemental pleading, and I'm going to attach that email, and you can figure out who.
And you know what? We're gonna
information.
attach sanctions to that email. We're gonna attach sanctions to our next hearing as
Well,
well.
good. Attach
Do whatever
they
you
shouldn't
all
have
need
sent
to
it out.
do, but we are in recess. Let me give you your adjourn date.
But Judge, we have to know what's gonna happen at our adjourned date. What are you looking for?
I'm continuing the hearing. I mean, what do you mean? What am I looking for? You had an opportunity to reply to the motion. What do you mean? What am I looking for?
But Judge, there's an order that overrides her motion telling the court what to do from the Third Circuit Court. Should we call the Third Circuit Court judge and explain to this court how to handle the situation? Should we need that? Should I file a motion for that?
Are you being condescending, Attorney Bijani?
No, Judge,
you
even
need to
though
see this
even though
email.
you
You
and
think
Ms.
that's
Fluker
kind
have
of-
Did
that.
you just ask me if I need to call another judge to tell me how to handle my case?
Oh, you're
No.
going to love this email, Your Honor. Because he dogged the 36 district.
I
judges
catch
out.
I
all
don't even know
kind of
she's-
shade, Attorney Bijani, okay?
Judge, I can't hear what you guys
Keep
are
the
saying.
condescending remarks to yourself.
I wasn't being
Thank-
condescending.
Yes, you are.
No, it
Yes,
wasn't.
you are. Yes, you are. Can I have a court date?
June. Unless you want me to just go in on.
Let me see. What's on June 1st?
Judge, we're requesting an adjournment within 7 days because at this point, my client is suffering irreparable harm. He's been paying property taxes, water bills, and the defendant hasn't paid.
I need to talk to my court clerk. Can you give me a
Yeah.
second? Excuse me, off the
Yeah.
record. 11:15.
Yeah.
This matter is adjourned to May 30th at 11:15 a.m.
Your Honor, my client would like to make a comment if possible.
He can make it when we come back. We are over the time that I'm supposed to hold my court staff. So we're
Okay.
done for today, okay? This
Judge-
matter is adjourned to May 30th at 11:15. That concludes this matter. I will see you all back here on May 30th at 2023 at 11:15. Yes, Attorney Bijani.
Judge, there's a continuing order for escrow payments that has not been complied with. And in accordance with Michigan
Yeah.
law, the defendant is
Now,
supposed
we
to
can
deposit
argue
that
this for
money.
20
Ms.
minutes.
Fluker,
because
can
we
I
tried to
speak?
do
God
that.
damn it.
Excuse
Oh,
me.
no. Oh, no, Attorney
You need to
Bijani.
see
You
the
are
email.
completely out of line.
Oh, I am? Can I
No,
please
you
speak?
don't know. That is it. You're done. Do not curse in my courtroom. You
what's-
wouldn't do it in anybody else's courtroom, Attorney Bijani. Don't disrespect me. Don't disrespect this court. And don't disrespect yourself. You're disrespecting yourself, Attorney Bijani.
Can I
You're
speak?
done. You don't have anything else to say.
So you're
You are being removed. You have the date. Have a good day. Court is in recess.